So in my submissions before the lunch adjournment were to the effect that the words other transaction are governed by assignment or subsale, and that doesn't naturally include an option, which is a different kind of transaction, which doesn't operate in substance like a subsale. And I just had one or two short points on the remainder of section 45 in answer to the case against me, just to complete my submissions on section 45. The first is a point made in my skeleton that the label that's given to the assignment, subsale or other transaction within section 45 is transfer of rights. The words,
sorry, I'm finding it a little hard to pick up every word.
Oh, I'm sorry. The label given to the assignment, subsale or other transaction is transfer of rights. And as I put it in my skeleton, that is an apt description if other transaction is something of the nature of a assignment of all the rights under the contract complete or a subsale. And it's as a matter of construction, it can be of assistance to see how the draftsman has labelled or the concept that he's created in or describing in the statutory provision. And it's a movement of rights. So rights are being moved from the potential purchaser to the sub-purchaser. And that's not what happens in an option grant. The second point is that my learned friend referred to section 45 subsection 5, which was a later amendment which made extended the relief to make clear that it could apply where there was a subsale as to part. Now in my submission that's a very simple provision. It would deal with a case where you bought an estate, a large landed estate, or you just bought 100 acres of farmland and you subsold half of the acreage. You can subsell and obtain the relief in respect of your 5 or 50 acres and retain and proceed to completion yourself on the remaining 50 or however many it is. It's not, and the mechanism for apportioning the consideration works very simply if that's its scope. It's not, it doesn't indicate that you can get subsale relief for, if you like, carving out interests, future interests in land. And it's not clear to me how that would help you get there, because if you needed 5 for subselling 5 of your 10 acres, it seems to me you'd need a special rule to enable you to subsell a sort of slither of land. But in any event, I'm not, in my submission there's a simple explanation for sub 5, and it doesn't assist my learned friend in making his case that 45 applies to options. I mean,
sorry, just to clarify, this provision, subsection 5, was in force at the relevant time,
yes,
unlike the other provision we were. Yeah. Okay, thank you.
And of course, in looking at it in substance, if it were to actually apply in the present case, it would make sense if it applied to really only something worth £100, because that's the interest that's been subsold, except that it doesn't make any sense, as I say. It doesn't help my learned friend. It's simply explained by the physical partition of the subject matter of the contract. My learned friend also refers, certainly in his skeleton, to the Vardy case. That is a decision of the First-tier Tribunal. It's obviously not an authority for this court. It is obviously a specialist tax tribunal decision. But in my submission, it's very fully and perfectly dealt with by the upper tribunal at paragraph 41 of its decision. It was factually a very different scheme. A company wished to buy land, so it created a subsidiary which it then funded to buy property from the vendor, and then on the subsidiary then declared a dividend which would be payable on or simultaneously with completion of the contract with the vendor. So the contract between the vendor and the subsidiary created for the purpose of the scheme completes, the dividend is paid up immediately paying the land up to the parent company, the £1 million whatever consideration is payable from the subsidiary to the vendor. The dividend is for no consideration. So it's said that subsale relief applies. The contract which has the chargeable consideration is disregarded. The acquisition by the subsidiary. The acquisition by the parent company is chargeable as if under section 44, but the consideration, it was said, is nil because it secured it by way of a dividend. There was a discussion in that case about the meaning of entitlement in the context of whether a declaration of a dividend could give rise to an entitlement to call. And as the upper tribunal explained, it doesn't help us at all in the issue in this case, which is whether a contingent or a contingent right to call in the nature of an option falls within section 45. So the Vardy point is completely answered by the upper tribunal. There's nothing more to say on that, and it doesn't help us with the analysis here. And then finally, on the authorities more generally, they do all, although they're obviously relevant background to the nature of the land transaction itself, and SDLT does acknowledge and work with the underlying property law. Each of the cases concern a different statutory or legal question, and none of them, Spiro or Wimpy or South West Railways, deal with the particular question in our case. And that matters, and it's a point made in the Spiro case by Mr. Hoffman, as it then was. And that's at tab 18. And it's the hard copy is page 78, so it would be 78 plus 4, I imagine, 82. And it's the highlighted part at the bottom on the right, G to H. And the point being made at H is that the court has had all these arguments by analogy. Oh, options are this, or options are that. They're similar to this, or they're similar to that. And in the end, what the court is saying, an option, strictly speaking, doesn't have it's not either an offer or a conditional contract. It doesn't have all the instance of the standard form of either of these concepts. To that extent, it's a relationship sui generis. But there are ways in which it resembles each. Each analogy is in a proper context or valid way of characterising the situation created by an option. But the question in this case, so in the Spiro case, is not whether one analogy is true and the other false, but which is appropriate to be used in the construction of the 1989 Act. And that whole same principle applies to our case. There are many ways of understanding an option by analogy or not. In the end, and it doesn't matter that somewhere in Wimpy or somewhere in a judgment in Spiro, the courts say an option is an entitlement to call for a conveyance. That doesn't mean it's an entitlement to call within the meaning of section 45(1)(b). And it's that provision that has to be construed purposefully.
Right, it has to be characterised in context.
In context, thank you. So they're my submissions on section 45(1) and why I say an option isn't in 45 at all. But I can deal briefly with just the alternative case, which is, well, what if my submission is wrong and an option is an entitlement to call within 45(1)(b)? And then I say, as both the First-tier Tribunal decided and as the upper tribunal accepted, the secondary contract is neither simultaneously completed with the original contract, and nor is it substantially performed on simultaneously with the completion of the original contract. And I wanted to start with the not simultaneously completed, because it does put my argument on substantial performance in context. So whether or not my learned friend is relying on it, I think probably he is now, but I think it's it's important. And the point, or the key point on this is that so we have a contract that's within A, that's the original contract. We've got the assignment or subsale or other transaction. That's defined as the transfer of rights. And then subsection 2 of 45 says the transferee, so that would be San Leon, is not, yes it is, sorry. The transferee, San Leon, is not regarded as entering into a land transaction by reason of the transfer of rights. But section 44 has effect in accordance with the following provisions. And 3 says, section 44 applies as if there were a contract for a land transaction. So that's creating a secondary contract, which is it has the characteristics that the deemed characteristics that allow 44 to apply. And of course, 44 is all about the conveyance of the underlying legal title. So there's a contract for a land transaction, a secondary contract, under which the transferee is the purchaser, and then we get a rule about the consideration. And so if you ask, what is, so I should then read the tail piece. So the substantial performance or completion of the original contract at the same time and in connection with the substantial performance or completion of the secondary contract that shall be disregarded. So that would relieve Mr. Fanning. But if you ask, well, what does it mean to complete the secondary contract? Well, the secondary contract is a deemed contract for a land transaction, and the land transaction is the acquisition of the leasehold. So the completion, the conveyance or the completion of the secondary contract must require a conveyance of the title to the leasehold property.
So the performance of the option.
The exercise and then, yes, performance of the contract arising.
Not the granting of the option, but the performance
the
of the option.
Can you explain in a bit more detail precisely why the subject matter, why you characterise that contract as being one for the actual transfer of the lease? Because we're told on the face of 45.3, we're told very little about what the secondary contract is or what its terms are. Are you getting there by reading it with section 44 and saying that must involve a conveyance?
Well, I think I begin with 45.1b. So we've got a transaction as a result of which a person other than the original purchaser becomes entitled to call for a conveyance. And if you ask a conveyance of what, in the context, given we begin with the original contract, it's a conveyance of the legal title, which is the subject matter of the original contract in 45.1a.
So you go back to the becomes entitled.
Yeah.
In 45.1b.
And the option would only be within that because you would say an option is an entitlement to call for a conveyance. And the conveyance is what? Well, it's this purpose, it has to be the conveyance of the lease or the title to the leasehold property. And it's said it doesn't matter that it's contingent on exercise, an option's good enough.
I see.
And so, and I would say that would be the only way that an option could fall within 45.1b, because the entitlement to call for a conveyance must be to a conveyance of the title, which is, or the property, which is the subject matter of the original contract.
And just to pursue that, then you say, just to make sure I've understood this, you then say that the completion of the secondary contract that's referred to in 45.3
yes,
must, given that background, must relate to the exercise and completion, exercise of the option and completion
yes,
of the sale.
yes, yes, okay. That's my submission. And that's what was accepted by the first tier and the upper tribunal.
And that there's a distinction in 1b between becomes and will become. Is that a point that
Well,
you make or not?
Well, I think I'm assuming at the moment that I've lost my primary argument, so that an option does fall within 1B. And I'm just saying, even if an option were within 1B, which I say it's not, you still wouldn't get subsale relief.
Yes, but going back to your previous argument, do you place any weight on the word becomes?
Well, in the sense that yes, it indicates a sort of present or vested entitlement, that you're to replace the original purchaser. And so to that extent, yes, I do.
Right.
But you, as I understand it now, what you want us to do is to interpret the second part of 3, assuming you've lost on land transaction. You're not just using this argument as a way of throwing light on the meaning of 45(1)(b). You've gone into hickey territory, if I may put it like that. You've assumed it's in 45(1)(b), and now you're saying, if I've got you right, that even if that's a land transaction, when it talks about completion or substantial performance of the secondary contract, that isn't just the grant of the option, that those words include the exercise and ultimate conveyance, and your reason for that is because of section 44?
Well, because...
Or
45(1)(b).
45(1)(b), is it?
The reason is, the only conceivable reason why an option would be within 45(1)(b), and this is really the approach the first tier took, is that it's enough that an option is an entitlement, even if contingent, to call for a conveyance of the leasehold title. And that's enough for...
But if it's enough, why do you have to do more than complete that which is enough?
Because 1B asks about the entitlement to call for the conveyance. The concept of completion is completion of the secondary contract. And the secondary contract is a contract for a land transaction. And so then it creates, in respect of this entitlement to call for the conveyance, it then creates the deemed contract that enables you to apply the machinery of section 44 to determine when is the effective date. And for example, what does it mean to substantially perform? But at all times, the question of what's to be conveyed would be the leasehold title. That's the relevant entitlement.
Yeah, I'm still struggling with this, because I understand the argument that these factors go to showing it's not a transaction within the meaning of 45(1)(b). But once you've accepted that it is within 45(1)(b), there is another transaction which meets the requirements other than the original purchaser becoming entitled to call for a conveyance, and you've accepted that an option is that, then 3, the opening words of 3, deems that contract, the option, to be a secondary contract.
No, with my submission, you're required to disregard the option. So that's subsection 2.
Which applies as if there were a contract for a land transaction.
I think what I...
Oh, I see. So, okay, so you're not...
I think if it helps, in DV3, Lord Justice Lewison made the point that there is no... Section 45 doesn't create a tripartite contract of some sort. It's not necessary to go that far, and that's not what 45 does. What it does is say you disregard the acquisition of the option or the actual land transaction entered into by the transferee, and then you identify this deemed secondary contract, which is entirely notional.
Yes, it's entirely notional until you get to the final paragraph of 3, which talks about what must refer to the actual substantial performance or completion of that.
Yes, because you
Deemed.
have
So
to-
we've partially come out
Yeah.
of the rabbit hole at this point
Yeah.
because there's no deeming of a completion. It's asking you to work out whether that secondary contract has actually been substantially performed or completed. I think that's what
yeah.
you may be
So
struggling
So you
with.
come back into, in the end, although the statute creates a deemed contract, it is always applied by reference back to the real world, which has the real contracts in it. And what it's done is, if you like, it might be too sort of woolly, but it's changed the shape, or it's given you the shape of a transaction which will fit within Section 44.
What I find more helpful,
Which-
actually, with respect, is not to have references to real world and so on, but just to look at the words. So when I look at the words in the little bit at the end of 3, and it says substantial performance or completion of the secondary contract, I must I say to myself, that is substantial performance or completion of the deemed land transaction, which has been defined as a secondary contract, which is a deemed land transaction, which will lead to completion by conveyance. Is that
Yes.
it? Is that what I'm
The
saying?
secondary contract is the label given to the deemed contract for a land
The deemed land transaction, yes. The
And-
transfer is not regarded as...
And in my submission, the contract for
If
a
there were
land
a contract.
transaction, the land transaction is the acquisition of the
Yeah.
freehold or the leasehold title.
Yeah, but maybe a route into this is to focus on the contract for a land transaction
Yes,
in the first line of 3,
yes.
which links back to Section 44 and the concept of a contract, and then
The
something
word
that I
secondary
wouldn't
contract may be misleading us, or it's maybe misleading me. It wouldn't be misleading anyone else in this room, because I'm thinking, oh, the secondary contract is the option, but the answer is no. The 45(1)(b) thing is deemed to be a contract for a land transaction, and the next part of 3 deals with the substantial performance or completion of the deemed land transaction, the thing, not the option, the land transaction or the deemed land transaction. And that means you've got to bring in 44(1)(a) and is to be completed by, I think.
And it's almost even less than that, which it doesn't actually say it deems the other transaction to be a contract for. It actually just says you disregard that.
Well, it
And
says,
then
no,
you
it
create
doesn't,
a
it
setup
doesn't actually,
for
with the very
deemed
greatest
contract
respect.
for-
It says Section 44 applies as if there were a contract for a land transaction. It doesn't tell you to disregard something. It tells you to treat something, the 45(1)(b) thing, as if there were a contract for a land transaction, which it
but-
then gives another word for, but we'll call it the Lewis contract, and then we won't get into...
I think
It's
to be
subsection
fair-
2 as well.
Subsection 2
2.
is a disregard.
yes, subsection 2 is, yes, but subsection 3 is different.
Yeah.
So subsection 2 says the transferee, so San Leon, is not regarded as entering into a land transaction by reason of the option.
Yeah,
So that's all disregarded. But section 44 applies as if there were this contract for a land transaction, and that's the kind of contract that fits within section 44. The land transaction is the acquisition of the freehold or the leasehold title. And so completion is completion of that secondary contract, which in the real world has to be done by a conveyance of the leasehold title. And we know as a fact that that maybe still hasn't happened, but certainly hasn't happened on the date of completion of the original contract.
Now, I think you were going to say something about it at the same time and in connection with, were you, at this point? Assuming you, as it were, had been driven back to this point.
Yes, we don't. We have the revenue have never taken any issue on the words in connection with, because in our case it was so far apart on the same time as, which is there simply in our submission was absolutely no completion of the secondary contract.
Right, that's the same time as.
That's the same, so that we didn't make anything of the words in connection with, and likewise on substantial performance, we said we're so far off that we didn't make anything of the words. So certainly there aren't really any findings of fact on the basis of the revenue making any
Right.
challenge in relation to that.
Okay.
Now, in that context, then, where the secondary contract is a contract which will be completed by conveyance of the legal title, one then asks, well, what does it mean to substantially perform that secondary contract? And substantial performance is because we've got a contract to which the modified or Section 44 is applying. We've got a definition of substantial performance, and it's really the bulk of the consideration, because we know that San Leon didn't go into possession, for example. So the only way this secondary contract could be substantially performed would be by payment of consideration. And on that, I say that the First-tier and Upper Tribunal also got it right. And the relevant provision on which we rely is subsection 3B2. Because the consideration for this secondary contract is the consideration given for the transfer of rights. And to determine that, you do have to look at the contracts. And it doesn't have to be in the past. There's no timing requirement there. You're looking for what's the consideration for the transfer of rights. And the transfer of rights there shouldn't be cut down and treated as the option in the sense of the acquisition of the equitable interest. Because in context, in my submission, the only reason, as I say, the option is within B on this, my alternative case, is because it's an entitlement to call for a conveyance of the leasehold interest, the title.
The difficulty with that is to be the last bit of 45.1 references. It's just a shorthand. References to the transfer of rights are to the other transaction,
Yes.
not anything else.
Yes, and
There's
so
a consideration given for the other transaction.
Yes. And so my submission, you construe that purposively in the context of this provision. It must be everything that's given for the option holder to acquire the leasehold or the legal title. So it's not the £100 option fee, because the option fee doesn't actually get it the leasehold title. It's got to be all the consideration that has to be given for it to acquire.
But how do you... I understand one loves interpreting things purposively, but the actual words do say the transfer rights it's a reference to the other transaction, not secondary contract or deemed land transaction, but the other transaction, which is the option.
Well, the transfer of rights is the label for the entitlement to call for a conveyance of the
The same transfer of rights throughout.
Yes, and so I say it just makes a mockery of Section 45 if you can stop at the consideration given for the option fee, which doesn't actually get you the property in respect of which you've got the right to, or the entitlement to call. Because what it is then doing is turning 44 into an exemption. And I mean, it's why an option should never be within 45 at all. But I say if options are within 45(1)(b), they're there by mistake, if you like, that draftsman's gone too wide and made an error. Does it matter? Well, we can see that there's clearly no completion until the actual conveyance of the legal title, and that, in my submission, does inform what you'd then be looking for in terms of the consideration of substantial performance. Because if we think back to Section 44, the substantial performance is in relation to the acquisition of that leasehold property. It's not interested in the substantial performance because you've got a right to do something in the future. It's looking at rights of enjoyment in relation to the underlying property. And so if it's a slight strain on the words, or you're giving them the word for slightly broader meaning, then that's, in my submission, what one should do. to make this provision operate in a coherent and sensible way, and in line with the policy which we saw clearly described by in the St Matthew's case in the judicial review decision. But as I say, if there's a strain there which feels really awkward, what it's evidencing is that the machinery in 45, which is an important part of section 45, doesn't work if an option is within 45(1)(b).
Personally, I find it easier to understand this as being something that illuminates the meaning or other transaction. I'm very unhappy at saying, oh, I don't like that word, so I'll read it differently, or there's some policy articulated by somebody that's not Parliament, and I'll fiddle about with the words. But I do understand more readily a submission that says 45 and 44 must be read together, and you can't just stop at 41 and say transaction and try and fit everything about. The fact that the machinery may be difficult or may be predicated on the ultimate conveyance, if I'll call it that, is to my mind better understood as a pointer towards other transaction. And if you lose on that, then you've got to make the machinery work. But anyway, that's just an old-fashioned words mean what they say approach.
And I put the argument both ways, and I see to make the machinery work, you have to read two in the way that the upper tribunal and the First-tier Tribunal read it. Those are my submissions on section 45. So I can deal briefly with section 75A. Just before doing that, the Revenue's position on remitter or not.
Remitter.
Yes, was really that would obviously be open to this court to do as the upper tribunal did and not give a decision on 75A at all. But if it regarded it as relevant, then it does have power to remit. But on that, my submission is it's a very short point that's between the parties. And it does seem rather disproportionate that you might add 2 years, or, well, that might be an overestimate. You add another 12, 18 months before you actually get a decision on this case. And that doesn't seem for a short point where we've got the facts. The facts have been found.
But what is the appeal against, though?
So I'm sorry.
What is the appeal against in this court?
How it arose is that...
No, I understand how it arose, but what's it actually... I mean, they haven't taken a decision on 75A, have they? So we can't say they're wrong or anything like that. We just don't know what the other tribunal would have done.
Well, how I understood it was that this... if my learned friend succeeds on 45, you would set aside the decision of the upper tribunal. And you can then either remake it or remit. But if you remake it, you'd need to hear the other argument, which is actually he doesn't win because of 75A. And in my submission, the court could hear argument on 75A, which is really just an alternative argument.
I mean, there is a case law in the context of the upper tribunal on immigration, but when it's appropriate for remission, when it's appropriate for...
Yeah, I think without hearing the argument...
You've got to hear the argument if you're going to take a decision.
It's a really rather different question.
I
can't really see, in general, if we think there's only one answer, so we can deal with it ourselves. But it is a completely different question. The 75A question.
You've got findings of fact, TT, but you haven't got
Decision.
No. So shall I say that
If we get to that, we remit.
if we got to that point, we would remit? What is that?
Or have another hearing.
or have another hearing.
Or have another hearing.
If we
did you want to say anything?
Just very briefly, it's just to gently remind the court of my submission just before the short adjournment, which was that in relation to 75A, I did comment that it was really the point that we do invite the court to remit back
Yes.
to the tribunal.
You needn't say anything else because we might change our mind if you.
Thank you, Madam.
No, the position that we take is that if we got to the point where 75A came into play, then we would probably seek submissions from the parties, and the question then would be whether it's something we could deal with or whether it's something we should remit to be dealt with by the UT. So I think by that means we avoid putting you both to the trouble of having a long argument about whether it's proper that we should do such a thing or not. I think we'll, I think sufficient until the day, will that, the question of whether that one arises or not. So just looking to my lord, my lady, that's our position, but if you're both happy with that, then we can leave it on that basis that your respondent's notice, as it were, is still there. And if we feel we need to come back to it, then we'll find a fair way of doing that.
Thank you, Madam.
Right.
So then if I could just check. Then that's the revenue case.
No, well, thank you, and thank you also to Mr. Habitus Lasky as well. Yes.
My lord, unless the court has any specific questions, I don't think anything new arose which I should.
Well, I think battle has been joined.
Precisely, and I would be trespassing on your patience.
Well, it's so long as you're not feeling under any pressure of time. It's I think unless either my lady or my lord identifies anything that definitely needs a reply, I think it's also our thanks to you and Ms. Sheldon for your submissions, and thank you to all of you for the way in which the appeal has been prepared and presented. In the normal way, once we've considered our decision and prepared our judgments, we let you have them in draft on conditions of the most terrific confidence, please, in accordance with the warning that will appear at the top of the draft judgments, and we'll then receive from you the editorial corrections that you may find, together with the draft order, reflecting, please, our decision and agreeing, insofar as you're possibly capable of doing so, all the consequential matters that might follow. We'll take written submissions, brief ones in relation to any matters that you can't agree, and we'll most certainly decide those without the need for a further hearing, unless we find ourselves having to deal with Section 75A, in which case we'll come back to you for more substantial assistance. Unless there are any other matters, that concludes the hearing. Thank you.